Thank you all for joining it. It's on data protection and privacy in the era of outstanding digitization. My initial idea was to arrange it as a round table. So obviously we don't have a round table at the hall, but feel free to get in contact with everyone who is over here as a panelist and ask questions. Don't hesitate to get in touch with everyone. So without further ado, I would like to present you the panelists, Radoslav Nikolov from Microsoft Bulgaria, Stanimir Nenov, that's the CEO of probably the most famous NGO in terms of legal advices. Nikola Penchev is the chief editor. We have Murat Kasim, who is representing 159 Limited. He's an expert in data protection. We have from the Data Protection Authority of Bulgaria, Maria Mateva, and as well as Desislava Nikolova right in front of you. And we have the PhD Nevin Fethi. She's a lecturer in Sofia University. She has quite significant experience and knowledge in the data protection field. We have Slavi Andrei from Amexis, and Mr. Robe from Technical University, who would like to join the session as well. So my initial idea is to give a few sentences about what exactly the personal data is. I mean the glossary, what is the data processor. If any of the panelists would like to add, probably Nicola, would you like to add something on the topic, or we can just jump to the right to be forgotten, the first topic that we would like to discuss? Feel free to start the discussion. I think your microphone is not. Is it? Okay.
It's okay? Oh, okay. Okay, I suppose since everybody is here, they already know what private data is and what data protection is all about. So I guess we can skip this part in general about stuff like data protection and private data. If the public wants to hear more about the general concepts of private data and data protection, it's okay to ask questions. But if you don't, I assume that all of you have a general knowledge about data protection. So is it okay?
Yeah, obviously. We can just, yeah, we can skip that and just go to the main discussion of the first topic, right to be forgotten.
Yeah, okay, I'm going to start the topic of the right to be forgotten. I'm not sure whether every one of you is familiar with this concept. The right to be forgotten basically is the right for an individual, a data subject, to request from a data controller the erasure of certain data, which finds irrelevant or inadequate. It's become a very important topic since last year, exactly 1 year ago actually. In June, the Court of Justice, the Court of the European Union, decided a case. It was between a Spanish citizen and Google, and also a Spanish newspaper, where the Spanish citizen claimed that he had the right to request from Google to remove some links with some links that refer to a certain article from an online newspaper which contained private data for him. The data was actually for auctioning of his repossessed home from a case that has been settled years ago. So it became really big matter because the court had to decide on the first hand whether to treat search engines as data controllers and whether they're obligated to remove such links. This was really big because if the court had decided that Google and all search engines are data controllers, now they have to apply the rules of data protection. So there are two terms regarding data protection, and one is data controllers and data processors, where data controller basically is the big processor of data who has to apply all the rules, where the data processor does not have to apply all the rules since he's considered a subsidiary of the data controller. Well, the Court of Justice decided that search engines have to apply all the rules of data protection, And they have to establish procedures for each individual to be able to request certain links to be removed. Now, this presents a very huge challenge in front of search engines because private data is everywhere. Google have made a transparency report since for 1 year. Just let me check the data. I have it here. They have it published. Every one of you can see it. It's called Transparency Report, and they publish such for many topics like copyright removal requests, governmental requests, and so on. And since just 1 year, the decision is read from the 1st of June, I think, 2014, they have already served 265,000 requests and removed almost 1 million links from the search results. Okay, that's really huge. Yes?
Because there has been a lot of misrepresentation and misunderstanding about this. Thank you.
Yeah, okay. I have to agree. I'm not sure whether everyone of you heard her. Well, Google does not really have to remove the links, but honestly, they do. They basically remove the links from the search results, as is the case with the Spanish Citizen. While the newspaper still has the article in respect of the freedom of speech, Google has now removed the link to said article. So if you type the name of the said Spanish Citizen, no link will appear in the search results for the said newspaper. So on the one hand, it's not just removal of personal information from the links, not just the links, but removal of the very links, which is really the big problem for search engines. If you have to just remove personal data from the link, I don't think it's a very big deal. Of course, it is, for sure, but they do have to remove the links, really, the very links to said information. And that's really the essence of what they do. And just, you can now have a look at it. They have removed 1 million URLs just for a single year. So, what I wanted to say is, I respect what you say. I believe you have right, but what they're obligated to do is really remove the links from the search results. I believe it's like this. Yes, sure. You have the microphone, I think.
Yep. Please introduce yourself.
Thank you. I'm Matthias Dreimer from the Austrian Federal Chancellery. I also was reading, of course, very carefully the case of Google Spain. And I speak as a lawyer, and on the one hand, especially as a human rights lawyer, and of course I see all the problematic as regards freedom to information and access to information. Can you change the past by just deleting links and so on? But I see the problem with this case that it is a very special, we never speak about the facts of the case. It's always said, well, there was the decision that somebody could ask that data about him were to be removed by the search engine. The court in this decision, and I do not want to defend the European Court of Justice, but just read it as a lawyer. The court makes very, very long a test of proportionality and said in this special case, because what was the case? It was a case that there was, I think, an auction or something like that 20 or 25 years ago about a person who had debts at this time, financial debts. But he could solve that in 1992 or something, and that what was advertised was an official information about this auction. So the case was completely settled. There was no relevance at all. And for him, as an entrepreneur, today, the first search result when you were Googling his name was, well, he had maybe went bankrupt and there is an auction, although this was really passed. And here the court says, in this specific constellation, there it might be justified that the information does not appear in the search engine. I see more the problem that how Google reacted then, because Google said, okay, if this is the case, then we will offer immediately to our users and so on a form where you can write in, I want to have that deleted. So the reaction of Google, to my mind, is a little bit the problem. I understand Google, on the other hand, they want to be on the safe side. But this is always the problem when you have court cases, that you generalize it too much. Thank you.
Yeah, thank you very much. This is really the big issue, in my opinion, because what the court actually said is that the search engine has to make a case-by-case assessment whether a request is reasonable or not. And this means that some procedures have to be established, similar to the notice and takedown for copyright procedures. And well, this is harder to just say, okay, we have a request, we will remove the URL, or we have a request and we will remove private data from the URL. It's going to be much easier for search engines to just act upon each request. And this does not seem to be the case. From the same transparency report, they have some interesting data on how much of the requests have been served upon, have been acted upon, and how much have been denied. And 60% of the requests have actually been denied. Which means that Google have established such procedures in order to assess every single request, and that's really, I think, the big challenge, because sometimes it's really clear whether the information is irrelevant, inadequate, whether the public interest is stronger, whether the right of freedom is stronger, the right of the public to be informed is stronger, and sometimes it is really a border case. The case with the Spanish citizen is I think it's clear for everybody. Not many people will argue that he's really right in his claims, but I've checked the data on what kind of requests they get, and it's most of the cases are actually for criminal convictions. So when you have a criminal wanting to delete private data for crimes he have convicted in the past, it really becomes a border case. Or when you have a prominent figure, perhaps the public interest is more important. So it's really hard even for me as a lawyer to assess some of these cases and some of the requests, and I believe it's not the search engine's job to make legal assessments. So search engines now.
No, it's just fine. I'll just pass that one.
Sorry.
Yeah, no, it's
sorry for interrupting you, Nikki, but as you said, it's not search engine's job to look after legal matters, but it's their job to provide relevant results. And in this case with the Spanish citizens, obviously they didn't do it, because the first result about this citizen was something that was actually in the past and not relevant. So I'm curious, do you know what was Google's reaction to this strictly technically? Did they change something in their index code, or what was their reaction to this situation where they put on first result, on first page, something that is not true and not relevant anymore?
Great, thank you for the question. Well, they didn't change much. They have some procedure from, excuse me, from even before the decision where Google removes personal data from URLs. By default, like social security numbers, addresses, bank accounts, and so on. But there's little they can do in order to, I don't know how to say, to disseminate in such a level the information from the links in order to know whether such inadequate information appears for said citizen, or they cannot assess the information for every citizen, so they don't have notice of what actually appears as the first, second, or the last result on search page. And so they have to act upon gaining knowledge. I think that's for sure. There cannot be a general obligation for them to actually monitor the data, and this is the European regulation as well. Service provider, we can argue whether search engines are internet service provider, but I'd say they are. They don't have the general obligation to monitor what kind of information they present to the public, and that's really reasonable. I don't think you can do it. Perhaps I'm not really that strong on the technical part, but that has to be really hard. When even the procedures that they have established for removal of social security numbers and so on are really not that, in general, not working that well. Even if they're developing. What they did after the decision is they actually implemented the procedure. It's very similar to the notes and takedown procedure for copyright if the public is familiar with it. But you have to fill a form presented to you by Google Form, developed in a way to evaluate whether it's a reasonable request. So they have to gather data from yourself, from the claimer, from the data subject, and the upcoming regulation, but we're not sure whether it will stay as it is, and the Court of Justice actually have pinpointed some stuff, if I can express it like that, that search engines have to check in order to assess whether a request is reasonable or not. And
we have a question.
Yeah.
Please introduce yourself.
It's actually more than a comment. I think we need to set the record straight first to understand what we're talking about. So first, this is not the right to be forgotten. Because if it would have been the right to be forgotten, then you wouldn't find the name of that person on Google, which is not right. You still find it. Actually, the original article where he appeared, it's still online, and it has been judged to be legal. Yes? So it's not the right to be forgotten. The second thing is that Google actually just de-index that specific URL when you search his name. So that means that if you do another search, you can still find that specific article. The third point that also needs to be very clearly is that the procedure is quite different from data protection to copyright infringement. In the case of alleged copyright infringement cases, there are, I think, something about 7 million search indexes that are being de-indexed every day based on a simple claim that is made by a certain person, and it's an entire business there. We don't want to go into that discussion. Whereas in the case of data protection, there were, as you said, 1 million in 6 months. So it's quite a difference between the two. But we need to be clear, because I also saw on the Twitter where this is not the right to be forgotten. This could be a right to be de-indexed if you have a case, but it's not the right to be forgotten, which might be, because we don't know how the data protection regulation would look like, might be included in the new legislation. Thank you.
Yes, I have to agree with that remark. It's really true. It's not essentially a right to be forgotten, because indeed, if you put another name, if you put another search, this result will appear. And basically, that really is the right to be indexed. I cannot argue with this, but just for the needs of the discussion, we can refer to it as the right to be forgotten, not the right to be de-indexed, if you're okay with this. And the data regulation actually speaks for it as the right to be forgotten. Yes?
Yes, we can just, yeah, you can go ahead. It's turned on. It's on, yeah.
Okay, thank you. I fully agree of what you just said. Exactly, it's nothing with right to be forgotten. And right to be forgotten is not set up yet, because it's a new concept of the new regulation. So the main conclusion of the court decision from data protective authority perspective are three. The first one is that Google is a searching engine processing personal data. And he's processing personal data as a controller, because Google is putting the purpose of the processing this data. The second point is that processing personal data as a controller, Google have to follow all the data protection standards at your European Union level. And the third point is that every individual has a right to request if he or she sees a problem, has a right to request to the searching agent as a controller to do some actions. So all the decision court is set on the data protective directive, which is currently the main law at the European Union. If my colleague want to...
Yes, if I can contribute, indeed, the Google case refers to the right to erasure, which is a right under the current directive, and it is an existing right. The main conclusions are indeed that the search engines are controlled. That is the most important conclusion of the case, and that they are controlled on a separate ground, separate to the third-party control, the publisher, who, in the case of the Google, had the right to process this data. The second very important conclusion is that this case indeed referred to a concrete person, but it has a huge impact on the whole approach toward privacy in the digital world, because it has encouraged companies to think more of privacy on an initial stage now, and to think privacy friendly with regard to persons. And about the right to be forgotten, it is for now it is more as a concept, a broadened concept that will be not an absolute right, and it should coexist with other rights, such as the right to information, for example. It is more a concept for now. Thank you.
I think there was a question from the back from the same lady. Do you have the question?
Yeah.
Thank you.
It's turned on.
It's on?
Yeah.
Okay, thanks. It was not a question, it was just an additional comment that maybe if you looked at the Google form, you also noticed that in order to for Google to process your request, you also had to identify yourself. So Google was actually processing even more personal information. And maybe this is also an interesting point to keep in mind.
Yeah, that's really the case. I've actually really printed it from Google's form. It's the same for Google, for Bing and Yahoo. It's essentially the same form. I checked them all yesterday. And you really have to identify yourself in front of Google in order for your request to be approved. This is essential. You have to provide an image of some document which proves that this is you. Google explicitly say that it does not have to be your ID card, your passport, or something like this. But actually, what can you show them that is not your ID or something that is equivalent to it? And they say they really process even more data when you show them your ID. But I know why they do it. They are obligated to do it by the proposed text of the new regulation. They have to do it every time. They have to make sure that the subject of the data really. Yes? Yeah, but I have to make sure. I know. Yes, it's just a proposal. It's just a proposal, but one has. I'm not really a specialist, but we can later give the word to our representative from Microsoft on that case. But I think they have reviewed the text, the proposal of the regulation. They've checked it out, and again, they just want to make it secure for themselves, make it sure that they're okay. And they say, yes, we do everything right in our opinion, and that's all. Basically, I would do the same if I was Google. Of course, I'm not.
If I may pop in, privacy was the term privacy was stated a few times the last minutes, and my opinion is that the way we perceive privacy today, it's not going to be the same in the future, as the Internet of Things and the way technology in the digital world comes into enterprise, into government, into health, smart homes, and so on. We will have a whole new definition of privacy in the future. Yes?
Just present yourself.
Valentina from Bosnia and Herzegovina. I am terrified when I listen that we need a new definition of privacy, because I think it's the final exploitation of everything. But I don't know how much it's related, but I'm curious about the real name policy of Facebook that decide upfront and calling, as they say, aggressively to people outing others that are not using the real name. And if you want to regain your profile, you need to send your ID, a PDF of your ID, passport. I don't think that they provide any security means, any encryption, anything. So, and it's now a strategy that it's more and more used against activists or anyone who speaks what the mainstream politics or something doesn't want. That I'm very interested in having some insight.
Yeah, it's a fact that corporations and people and organizations are collecting data, and there are not really strict regulations how this data is used, how long is it stored, where is it stored. It's not so far away when if we talk about digital technology in the healthcare, for example, when we talk the smart wearables and so on, when a doctor one day might call me and say, Mr. Ninov, it's time for you to go to the hospital, you might receive a heart attack. So this is a really big interference in my personal world. But we have to pay the price in order to advance our world. And maybe that's the price, the change of the definition of privacy.
Like I said in a panel yesterday, privacy is a rather difficult concept to define. I don't think there is a common definition, at least that's not why there is a myriad of books trying to define it. Rather, thinking of privacy as a contextual concept also makes a definition of privacy change. It's an evolutionary concept. It will evolve in some way. As for the right to be forgotten, one of my biggest critiques is that Google isn't, and the other search engines aren't making adequate analysis of what is actually being requested. We made an attempt to remove information or de-indexed information about a CEO for a think tank in Sweden who had made a terrible statement in a debate where he compared denial of climate change to the denial of the Holocaust. It's a very terrible thing to say, and he admitted that he had said it. We tried to de-index this. It shouldn't have happened. He was a CEO of a think tank who has power in Sweden. It got de-indexed. Google de-indexed something that was very important that it stayed on the internet. Then we got them to de-index it, but that's not the issue. So I think one of the big problems is that Google, in their document, they say that they will make an analysis of what is in the public interest. And Google should not make a decision of what is in the public interest.
So in that sense, if you just allow me, I would like to cite something. It's the World Home Affairs that concluded that the criteria for links that can be removed from search engines were vague, ambiguous, and unhelpful, and that the private companies should not be responsible for policing content online, which is just as a continuation of what Jacob just said. Any comments from the audience? Probably from the Data Protection Authority, maybe? Who shall be responsible to decide which links shall be removed or not? Shall we just transmit this to the search engines, or
Thank you.
the obligation?
First of all, I would tell you my opinion. Data protection is set up not to stop the social life, because the social life is impossible without exchanging personal data. What we are trying to do is to put a standard which every controller and processor should follow in order to process the data rightly. So if the person give his consent to the social network, his data or her data to be processed in this social network, knowing the policy, the private policy of the social network, this is a problem of the person. Of course, social networks, they are controllers too. They have to follow the standards. But we too have the right and have the obligation to know what's going on and to give or to not give our consent to such controllers.
If I can add, it should be a more case-by-case assessment. We cannot make a general conclusion about how to decide on whether to refuse or to comply with a request of a citizen. It should be like a case-by-case in which all the circumstances are taken into account. The nature of the data, the context in which the data have been given, the prevailing public interest or not. In the case of Google, on its European dimension, I think that a proximity to the citizens who request removal of data is very important, because the public interest could be assessed only in a local environment. And proximity is very important, and it should be considered from search engines when decide upon whether to refuse or to comply with the request of a citizen. But it should be a case-by-case analysis in any case.
In that sense, you said that it should be a case analysis, but I've got a question. How do you think the smaller search engines will respond to this obligation to assess? As Nicola just said, there's been over 1 million submitted requests. And yeah, and I'm just thinking about how the small search engines will just respond to this obligation.
It's an interesting question indeed. Probably it should be privacy by design or by default policy, where you set certain criteria how to process data. Yes.
But privacy by design, and it's a very interesting concept as well, and all the current standards are trying to put that on place in order to have it in place before starting processing data. And I think what you're talking about is a matter of proportionality as well.
If I may have a word, it's really a very complex matter. As Jacob said, I believe his name was Jacob, privacy hasn't really been defined. Even the very concept of privacy haven't been defined, so we cannot expect from a search engine, whether it's a big search engine or a small engine, to actually make a legal assessment of whether a certain individual has the right or do not have the right for his private data to be removed from search results. It's really something that a government can put standards, but I don't really think these standards can work in every case, because most of the cases, yeah, they may be clear, but there are a lot of border cases, and it's a very, very complex procedure to evaluate if a certain request should be granted or not. And this is not something, in my opinion, that search engines should be doing. This is not their job. This is not what they're good at. I really only checked how Google did it because I only had so much time, and they have actually gathered a council of professionals, really very famous and prominent professionals in the area of data protection. They have made a number of meetings in many big cities in Europe on just make some internal standards for Google to know how to react to such requests. And this is Google. You cannot expect this from a small search engine. And until now, the criteria are really vague. It's, I mean, what do they say? The data is irrelevant or inadequate. You cannot strictly assess which data is inadequate or irrelevant. And that's why we cannot just examine the matter only in view of the right to be forgotten case with the Spanish citizen, because if we only look at this specific case, it really seems much easier than it actually is. But that's not the case. It has to be a really complex procedure for search engines, and that is, in my opinion, not something the society can expect from search engines.
Please. We have a question from the audience. Let's just allow the lady first. Introduce yourself, please.
Rumiana Atanasova. I would like to come back to what we have already said. Well, we haven't discussed the definition, but there is already a definition, and My question is about your opinion concerning, yes, data which is privacy related. And here we have already the definition, what can identify you. But there is also another two areas, minimum two areas, sensitive data and data which may harm third-party interests. And here I would definitely agree with the two ladies that there is a need for those who control, who take the decisions to be, how to say, to have a definition, to take the decision what data is this which can be sensitive or which can harm third-party interests.
It's working? Yes. Yeah. First to present myself, Radoslav Nikol from Microsoft Bulgaria, working with the government administration here in Bulgaria. I was not supposed to exactly speak in this part of the panel, but just to add something, because I'm looking a bit as an external person to this discussion. But it seems like every one of us is trying to throw the problem into the other person. I mean, we have the regulators here, we have the data processors here, the big companies, and every one of us is consuming all those services online. I think we are going in the wrong direction, and we have to understand that each one of those stakeholders has its own responsibility. So every one of us should take his own responsibility about his personal data. And no matter whether we are acting as single persons or representing an organization, we're the one who are responsible for our data, and we're responsible for where we're putting our data. So this is, how to say, my statement from personal point of view. Now, as a representative of Microsoft, I just want to add that we at Microsoft are taking privacy very seriously. And one of our goals is to be 100% transparent to our customers what is happening with their data. So there are a number of definitions and a number of regulations and already standards that the industry and also regulators developed in this area. So from this perspective, we try to be sure that every one of our customers is aware where his or her data resides, how we are treating this data, and to be sure also that we comply with all the regulations. And I might mention also that one of the most tough regulations in the area of privacy are set by the European Union. So from this perspective, I think the big industry and all those big companies have their responsibility also to 100% provide transparent information to all the users of the online services nowadays. And with this, I want also to take maybe one or two more questions and discussion about these topics. This topic, and also move to the other topics in the panel which are related to big data, to cloud.
Yeah, absolutely. I mean, our second topic was the data protection in the cloud. So we may just... Yep, absolutely. Sorry about that.
I just wanted to join in with the interesting fact, since we had one question about Facebook. How many people here does not have Facebook profiles? Yeah. Or perhaps I should say has not created. Well, even the one thing that perhaps few people know is that even if you haven't created a Facebook profile, Facebook still, by your friends, can create a shadow profile for you. So basically, currently I haven't created a Facebook profile for me, but I already have a shadow profile thanks to my friends. And this was something which has been discovered just by accident when Facebook have released their backup data feature. And then someone noticed that when you back up your friends, your Facebook data, you don't get only the list of your actual friends, but you also get the list of your hidden profile, shadow profile friends. Just wanted to jump with that.
Yep, okay. So any comments from the audience? If somebody would like to add something, or we can just start the discussion over the cloud computing and the data protection, where I think that we're all in the cloud currently, more or less. We're using the cloud services, even though sometimes we don't realize they're actually cloud services. And the main issues that raise who and how processes our data, how it rests, what kind of security measures are taken, how the cloud providers are respecting the legislative issues, and whether users shall be informed that the cloud provider mines their data for advertising purposes, for instance. And this is essential. So the transfer of personal data to the countries outside the EU currently is not permitted. At least those countries have an adequate level of data protection. So such level of protection may be secured by either adequate legal regulations, the safe harbor certification, or sufficient contractual basis like the EU model clauses. Radoslav, maybe you can just add something about this topic about the contractual clauses, and maybe discuss the role of, I don't know how many in the audience are actually familiar with what Article 29 Working Party is doing. What is this body? You can, yep, we have a few hands. Basically, this is, let me just find, or we can ask our representative from Data Protection Commission just to add something about the Article 29 Working Party, if you don't mind. Yeah, sure.
Article 29 is set on the base of directive. It's the Article 29 of the directive, and it's composed from all the data protection authorities at the European Union level. This is the highest forum where we can make our decisions, opinions, and assessment as well. So from this forum, we implement these opinions at the national level, and it is mostly to harmonize the implementation at the national level within the whole union. We, as Data Protection Authority, Bulgarian Data Protection Authority, we are part of the Article 29, of course, and the chair of our commission is the vice chair of the Article 29 as well. So we are very highly level represented there. Article 29 is dealing with the most painful issues, and we issue very good and very well-based opinion on the legal base, which is currently the directive. I hope it was useful.
Yep, absolutely. Thank you. So,
also maybe to add something from my side, the technology and the whole industry and we as users, the things should be going into how to say clear direction. I mean, there should be some standards and there should be some regulations that we all have to oblige and follow. And from this perspective, I think it's good the industry to take more care about complying with all those regulations that we have. This from one hand, and on the other hand, we also witness that the industry itself creates a lot of standards. And from this perspective, recently there was another standard issued for privacy in regards of cloud services, ISO 27018, which is also a clear guidance to the whole industry, how in the cloud the things related to privacy should be standardized. At Microsoft, so far we have been trying and being successful to ensure that we are both compliant with all the regulations developed by the European Union, and on the other hand, we ensure that we are compliant with the standards set by the industry. And recently we stated that we acquired this ISO 27018 as a standard for our commercial cloud services. So from this perspective, it's also good for our customers to know this and based on this, take their decision how to use our services and what will happen with their personal data in the cloud.
Great.
I just want to add something concerning cloud computing. The main issue here, from a data perspective authority view, is that this is connected to the transferring of data, because the person doesn't know where exactly the server is, and in most of the cases the server is outside of the European Union. So the three main legal instruments we just mentioned here, like Safe Harbor, which is currently at revision between European Union and US. The second, or maybe the first, is adequacy decision from the European Commission. And the third one is the contracting clauses, using of these clauses. So from our perspective, is very important the service provider to ensure with the documents that he follows these rules, and there are some rules which will allow the Data Protection Authority to check not only if the server provider follows the rules, but how they are implemented, and to check even the servers regardless of where they are.
In that sense, I would like to ask a question on how does the definition and the application of the EU personal data concept may be considered in the context of anonymization, pseudonymization, and encryption of the data fragmentation in cloud computing. We all know that the data is encrypted while it's in rest and while it's stored to the cloud computing. But can we just, how this definition applies to encrypted data, the personal data definition? May we still consider this data as personal if it's encrypted and the only person that has the decryption key is the...
There is the question is
yep.
to me. There is an opinion of Article 29 group that encrypted data is still personal data. But here we are mixing 3 or 4 different things. Anonymization and pseudonymization is a type of processing personal data, and this type is not connected at all with the transferring of data. So the main issue in cloud computing is transferring the data. Anonymization,
yep.
Data could be personal data still, and it's only a type of processing data, but it doesn't apply to cloud computing directly, at least.
Mm-hmm. Okay. Yeah, go
Just
ahead.
a word. As far as these techniques are concerned, they're really very helpful in order to bring more privacy. But we say that if one has the key to revert this encrypted data into personal data, then this is considered as personal data, because in many cases someone has the key to bring this data, to personalize this data again. So there's always the risk to personalize this data again. With regard to cloud computing, this is a big challenge for privacy and a big concern for data protection authorities, because it refers to a very huge amount of aggregated data that could sometimes lead to profiling at a very large scale. For us, it is very important that the core data protection principles are preserved. The one of purpose limitation and the one of data minimization. And for us, this is a guarantee that that privacy could be ensured, compliance with the core data protection principles.
Well, any other comments from the audience? If you have anything to add, maybe? Yep.
Just a short thing. If data is transferred through cloud computing services, it doesn't necessarily mean that it's being encrypted in transfer or at rest. It depends on the policies that the company is actually adopting. There are some companies that are much better on this and some companies which are much worse on this. But it doesn't necessarily mean that all the data is encrypted.
Okay.
Yes, that's why we need standards, and we also need transparency. You're right. Every one of us, as a single person, needs to know how his data processor is operating with his data, and what are the standards to which it comply and adhere.
The issue here might be that the user it's not familiar with the technology, and okay, the company which provides driverless cars explains the users how things work and what data they collect, but the user, he wants to ride in the car without a driver, and he won't really consent what data he's providing to the company. There are companies today that advertising companies that sell 1.6 million banners per second, depending on the user interests and users' favorite colors. For example, they know what colors I like, and they serve me banner depending on the. Personally, for me, there are companies. Okay, now we're going in the smart wearable. Companies will know what my blood pressure is, what my pulse is, and so on and so on. So here we have to talk a lot about data protection and mostly about how we could prevent cyber attacks, because here cyber attacks could happen not only virtually but physically, because the technology goes into things, into our watches, into our cars, Google Glasses, and so on.
Yep. I have one.
Also, I would like to discuss this topic from a more technical point of view. Personally, I think the problem with privacy, be it with personal computers or cloud computing, I don't think that the encryption algorithms or the way we protect our data, because I really believe that you guys at Microsoft or even at Google and Amazon, that they had reached a pretty good level of protecting data. But what I think is we still have issues with the so-called human element. Personally, in my free time, I'm trying to educate people on why their private data matters, on how companies might misuse their data. And what I notice is that most of the time, people don't know how much their data is how much they're sharing of their data to the public domain, and they're not really realizing how much they're sharing. And I would personally approach the issue by making sure that people are really aware of how much of their data is being published, and they become really thoughtful, really controlling of their data. And I think this would really help us to not also protect data better in the cloud, but also in any aspect. Because we know it's people who control computers, not otherwise. I mean, still, but yes, there was a comment.
Hello, my name is Mirana Taskova. I'm a data protection lawyer. Actually, I was listening. This conversation is very interesting, and thank you to everybody. But I would like to mention that there are rules existing, and the data protection authorities work on that. There is an ordinance about the technical and organizational measures. They stipulate who should take what measures depending on various factors, depending on how big is the company, because you realize that companies like Microsoft and Google cannot compare to some small companies that just started work. So I'm sure that there are some companies that encrypt their data, but I'm also sure that there are other companies that take very good measures to protect the data so actually can be processed securely. Also, of course, there should be transparency because the data controllers, this is their main point. They should provide information, whether via terms and conditions or otherwise, how and what they do with this data. And with respect to your comment for selling the data, I'm not sure that these companies are selling personal data, but statistics, which is a little bit different. So I think we should make a certain difference between personal data and statistics. This is one thing. And my last comment here is actually what my main concern with respect to cloud computing is, except what Ms. Mateva said about the transfer of data, which of course is the biggest concern. My other concern is the applicable law. Because we have data controllers, but most of the companies are in various countries, and then it becomes a very weird question, who is the data controller and which law applies? And maybe here we should think about the 29 working party opinion on applicable law as well. So that's what I wanted to say.
Also, I'd like to answer to your comment. I think that that we mentioned that the fact that data is being traded, I think everyone in this room accepts this as a fact because personally I think it's not only statistics which is being sold to interested entities, and I can give this by exact examples even by huge companies, but I don't think this is in the scope of what we discuss here. But this is really happening. I mean, I'm organizing a lecture about this. And even in great companies, there are occasions when certain employees, they just abuse their need to know, and they violate these established rules. But these are just single cases. As you said, I agree with you that perhaps we should try starting work in a way in which smaller companies also provide clear information on their users. Okay, look, your connection to this website is not encrypted. Your data is stored here and here and here. We got your mobile phone. We do this and that. In Bulgaria, I'll admit, a lot of the services which I see on our websites still do not have anything like that, and this is a major issue.
You can just answer.
Thank you. Thank you, Mirena, for the very valid point, because it's true, the applicable law is an issue here, because most of the company who is providing cloud computing are outside of Europe companies, and you are absolutely right that Article 29 is working on this issue regularly. But because we already mix the things here, two or three things like big data, Internet of Things, and cloud computing, maybe this is the moment to say that the new approach which data protector authorities have right now is a risk-based approach. So this risk-based approach obliges the company to do this risk assessment, and not only from their side, but data protection authorities, we are doing our risk-based approach and risk assessment from our side, And maybe this is the way to fix or to make rules in these big issues. Thank you.
Okay, so we have just 10 minutes left because the lunch is coming. What I would like everyone to add is your takeaways. Maybe we can just start with the guys who are in front of you. Just a short 1 to 2 sentence takeaway from this session as what do you think should be remembered as a discussion or just as your final thoughts. And okay, yeah, we can just...
Okay, I'll just only take 30 seconds to say. Okay, in my opinion, data protection is a responsibility for everyone. It's not just companies, it's not just controllers of data, it's a responsibility for individuals. If we are responsible as individuals and we know what our data is used for, what it is processed for, I think it's okay to let companies process that. That's really what I can share from my personal opinion.
My takeaway of the discussion would be that still there is a lot of discussion on the topics and a lot of information. There are a lot of surrounding things around the privacy that we add, and it's not only the privacy as a single problem. So my takeaway is to continue the whole this discussion and give more visibility to the problem.
Well, I will quote the editorials at Wired. You aren't just going to lose your privacy, you're going to have to watch the very concept of privacy be rewritten under your nose.
And perhaps I can follow up on that quote by myself. I think it's pretty normal. I mean, we are living in an age where technologies and software concepts are constantly being developed, and each year we are seeing new things happening. I think it's normal for privacy concepts to change like that. What is more interesting for me, because I'm a more of technical guy, how actually big companies like Microsoft or Amazon or Facebook are going to move on in the big data age. Because we know the problem with big data is it's really big and it's pretty hard to manage it, right? And what will be interesting for me is to see how exactly we are going to manage all this data, and of course the most important part of it, the privacy of this data.
Okay, maybe some final takeaways from your side.
Thank you. From my side, I will be more philosophically. I will take more philosophical approach because until the moment we care, everything will be fine. Because if we care for our privacy, yes, the world will develop. The technology will go ahead, of course. But if we care, we will be able to put some rules. The problem for me is that most of us doesn't care. So this is an issue. Thank you.
Yeah, my takeaway is that privacy has value. Today we face a loss of trust, and we have to restore this trust. And we place very much hope with the new regulation, with the current reform, because it will lead to more enforceable rights, for better transparency. But what is very important is that data subjects, consumers, have to develop responsibility and to develop a culture of privacy and to be an active part and to play an active role in the whole process in order to regain control. Thank you.
Thank you. So if anybody else would like, yep, absolutely.
Excuse me for interruption, but I think the privacy is already changed because we have the right of privacy. This is Article 7 of Chart of Fundamental Rights in EU. And also we have the right of data protection. This is individual right provided by Article 8 of Chart of Fundamental Rights in EU. So we have to consider this new reality in law. And this is the new reality in our world too. Thank you.
Thank you. Anybody from the audience? If you don't have anything to add, we can just go. The lunch is ready. Thank you for attending this session. Obviously, there will be a lot of discussion coming up.